You never know the person who's listening to it, what kind of day they had, what opinion they're going to have on the issues. We like to think it's this perfect balance the scales system where everything's even and they just look at the issues, but they're people and they're human. And so sometimes they are able to sort of take that lens off and just look at the facts. And then other times they pull in these reasonings that we don't understand or that we just don't agree with. Hi, I'm Emma.
And I'm Courtney.
And this is Lemon Law Unpeeled, the Lemon Law podcast. Today, we are going to be talking about initiating lemon law claims and alternative dispute resolution options that consumers have in trying to get the claims resolved without having to go through a civil court to trial. So first, let's talk about initiating the lemon law claim. So often, consumers will first contact the manufacturer, and most lemon law require that they do contact the manufacturer and let them know, hey, I have this lemon law claim. What are you going to do about it, or what can we do about it now without me having to retain counsel or go to court? And Courtney, I'll let you talk about this, but most manufacturers, they open up a case, they open up, a hotline or a tech line for them. And then really, in my understanding, is it doesn't often really go anywhere. It's a lot of sending back to the dealership or a lot of lip service sort of communication between the customer care center and the consumer.
Yeah, Emma, I think you're right. I think it's exactly a lot of lip service. We have potential clients, potential leads calling us all the time saying, I opened this claim with them and I've sent them all of these documents and we have 17 emails going back and forth and I've spoken with 4 different people and I have all of the confirmation numbers and all of the emails and all of the phone numbers, but I have no offer. Or I have this very small offer, or I have an offer to reimburse me for a month or 2 of my car payments, or perhaps an extended warranty, but it's really nothing of substance. And that's why we generally do have to get involved and we then file a claim.
Yeah, and we have had it before where the manufacturer does buy the vehicle back, but usually it's in a very obvious, very in-your-face type lemon law case where they can't really deny it, right? Like the vehicle is just sitting at the dealership. They can't get it to start. The dealer can't fix it. And there's really nothing else that can be done. But I would say it's fewer and farther between that we have situations like that, because most consumers that call us for assistance, they either haven't contacted customer care and are just coming right to us, which you also can do, or they've been getting the runaround, lots of emails or a lack of communication from them, and they're just generally frustrated and need some help or assistance. We have had it too where, so when clients reach out to customer care, and let's say customer care denies their buyback claim, most customer care representatives will include within that denial email resources to alternative dispute resolution programs that manufacturer participates in. For example, the Better Business Bureau, or the BBB as we'll refer to it, or the National Center for Dispute Resolution, NCDS. Those are the 2 most popular alternative dispute resolution centers that clients can use depending on which manufacturer you have. So for example, Nissan uses the Better Business Bureau. Chrysler uses NCDS. So, Courtney, I'll let you talk about, I know that you and I have both handled claims through the BBB and NCDS. How are they usually done? Are they in person? Are they remote? Are they on the papers, which I'll let you discuss what that means? Or how are these hearings conducted through the BBB and NCDS? And what has been your experience with them?
Yeah, there's a few different ways that these proceedings can go. So on the papers means that we send in all of the documents. We send the purchase agreement, the repair invoices to this arbitration program, whether it be the NCDS or the BBB. And that independent arbitrator is going to look at those documents and make a decision just based on those documents that he or she has in front of them. A lot of times it's at our election if we want them to be on the papers or in person. A lot of times we feel like it would be more persuasive if we showed up in person. So I have done that on many occasions. They are tough to win at, though. It generally does have to be a very blatant lemon law case, kind of like what you were describing before, where it has to be an in-your-face lemon law case to get resolution from the manufacturer's customer care numbers. This is actually pretty similar. They can't award money based on breach of warranty. They can only award a buyback under the Lemon Law, and it has to be very cut and dry. It has to be very clear. The in-person ones that I've conducted, we have gone, it's almost like a little miniature trial. I give an opening, the manufacturer's representative will do the same thing. I'll then have our client testify and talk about what's been going on. We'll each give a short closing explaining the law, and then generally the arbitrator will ask to go test drive the vehicle. And that can be a great thing or it can be a terrible thing, depending on if the issue is verified and if the issue is one that is easily identifiable. I think in every case that I ever had where we test drove the vehicle and the issue did not occur, we never saw the buyback. Whereas the ones where the issue did occur and it was very clear to feel, we were driving and you felt the shaking through your seat, for example, those we did win a buyback on. So again, like we were saying, it has to be a very clear-cut Lemon Law case. It can't be a breach of warranty case. We're not going to be able to get money damages. And if we're able to get that buyback, fantastic. Everybody's happy. If we're not, we can then go ahead and file a lawsuit, try again for the buyback, or in lieu of that, money damages under breach of warranty.
Yeah, and that's where things can get tricky. So most of my experience with the BBB and NCDS, I've never done one in person. I've done it via telephone or on the papers. And I actually prefer on the papers. I don't know why, but I feel like, because usually we, as you know, we will submit a memorandum with it, explaining the law, explaining why our client should get the refund or the repurchase. And I just feel like it really lays it out very clearly for the arbitrator to know what the standard is, know how we fit that standard, and that they should award in our favor. Because usually the manufacturer is just saying that we don't meet the threshold, we don't meet the standard, sort of like a blanket kind of response. Whereas when we get to do it on the papers and actually write that memo, I just feel like we have a better time getting the point across, and the arbitrator can sit and sort of pour over that paperwork, right? They can read it, they can cross-reference, they can look at the case law we've provided. Whereas when you're in person, it's very hasty, right? We've got to make a decision. We've got to listen to everybody chatting back and forth. You might forget something. Not everything's written down in front of you for you to look at, basically. And sometimes if a client has to give testimony, as you know, that can go either way. Sometimes consumers can be great and really good at sticking to the point and expressing their issues with the vehicle. And then other times they get nervous or they get sidetracked and start focusing on other issues and kind of pull the case away from where we want it to be. So when going through those programs, although we don't really go through them anymore, except for in states where they require it, usually on the papers is my preferred method. But states like Illinois, for example, if you have a valid Lemon Law claim, you have to go through alternative dispute resolution first before you can file your civil case in court. But Courtney's right, too, in that they're only going to determine whether you have a Lemon Law claim. So if you don't fit the bill for a Lemon Law, it's just a denial, and it's kind of a waste of time. And what's been happening as of late, so we haven't been going through the BBB or NCDS unless we have to, like per the state, because they don't award attorney's fees and costs. They've kind of backed themselves out of that and have said, listen, we will determine whether we think the vehicle's a lemon, but as for attorney's fees and costs, that's for you and the manufacturer to figure out. So, of course, I've had situations where the manufacturer either just does not respond to my inquiries as per, hey, we have this judgment, are you going to pay our fees as well? Or they just flat out say no. And, what we would do is we obviously give the consumer the buyback, but then we don't get paid for any of the time or effort that we put into the case. So if we don't have to go through the BBB or NCDS, we don't, because then we'd have to charge our clients. And it just ends up being more difficult and making things more complicated than just going through either the civil court system or the applicable attorney general's office, again, if it fits the situation that we're in. So, for example, with the attorney general's office, right? Because that's another option that we have. You can go through the New York State Attorney General's office, Georgia's Attorney General's office. They have very good programs in place for Lemon Law, But what's tough about New York is New York's Attorney General's office, same sort of thing. They'll determine whether they think you meet the threshold for lemon law, but they're not going to award counsel fees. But Georgia is. So it's one of those things that sort of state by state evaluations in terms of what's the best method for the client to go through and what is going to be most beneficial in the case in terms of how they're usually handled. Because Courtney, like you said, with the BBB and NCDS, it's kind of a toss-up, right, as to what sort of result you're going to get.
Yeah, absolutely. Like we were saying, it does have to be very cut and dry. With filing a lawsuit, we can be more persuasive. We can admit more things into evidence. A lot of times an arbitrator or a judge or a jury will go out on a limb a little bit more and may award in a case that really could go either way. Whereas BBB and NCDS, they're not going to award for our client unless they are very, very clear that it was a violation of the law.
And have you had this too? And we've had consumers call in saying, hey, I got my award mostly from the Attorney General's office, right? I got the award for a buyback from the Attorney General's office and the manufacturers ghosted me, basically. How do I enforce this? And that's the tough part too with these alternative dispute resolution groups. Now, with the BBB and NCDS, most manufacturers, they just comply, right? They don't mess with them because it can affect their business rating and things of that nature. But I have had it where consumers call in and say, I won in front of the Attorney General's office. They're not complying with the order. Can you help me enforce this? And unfortunately, we don't really have methods for doing that because the Attorney General's office doesn't really provide the support for having it enforced. And now mainly I'm referring to like New York. New York Attorney General's office is where I hear this complaint the most. Georgia is very strict. You have to comply with their decision within 40 days or else you'll get penalties. But my understanding and what I've heard about the New York State Attorney General's office is there's not much bite to their award, right? They don't really have any teeth to force the manufacturer to comply with it. They make the award and then that's it. They kind of go away. So that's what can be tricky too with these alternative dispute resolution programs is getting that decision enforced is not as easy as it may seem. And there also is, so in the civil court system too, Courtney and I have a lot of experience with other dispute resolution programs outside of the BBB, NCDS, and the Attorney General's office. So some states like New Jersey and Pennsylvania, when you file in the civil court, instead of sitting and waiting to go to trial like maybe you would in New York or Maryland, they have an alternative dispute resolution system. It's not necessarily a program because that's a little bit different per state, but they have arbitration. So basically, within about 6 to 8 months of filing, it depends on the county. Everybody's a little different. New Jersey's is more consistent in that respect, but Pennsylvania, for example, it all depends on the county you're in. But approximately 6 to 8 months from filing, you'll get an arbitration date. And basically, the arbitration program in PA especially is for any case whose value is less than $50,000, you can go in front of a panel of arbitrators to have your case heard and get an award. The award is appealable, but it really helps cut down on cases that just sit and wait to go to trial because it can help either side, right? Maybe the side that's like, no, I'm going to win. I know I have a good case, and they realize there's a bunch of holes in their case that they didn't notice by going in front of this panel, so they resolve it, or vice versa. It really helps cut down on those cases so that we can efficiently and effectively get these claims resolved without sitting and waiting to go to an actual like jury trial or bench trial. And Courtney, I know you've had a ton of experience in New Jersey, working on New Jersey arbitrations as recently as yesterday morning. Talk about your experience with them. And I think something that's really important too for you to touch on is how the arbitration system in New Jersey has changed since COVID. Because it's really, I think the in-person versus Zoom, I think that's had a big impact too on how these cases are handled.
Yeah, Emma, I've handled hundreds of these arbitrations in both Pennsylvania and New Jersey. And as a matter of fact, when I started doing them in Pennsylvania, the arbitration system there wasn't even all that old. It was something that had been implemented not even that long ago in an effort to clear some of the dockets in the court system because there were just so many cases. And by having these arbitrations, like you said, a lot of times it resolves these cases. I would say a good 75% of the time, these cases would resolve at arbitration level. It would almost be like a compromise. You know, maybe I'm not thrilled, you're not thrilled, but we can both live with this award rather than appealing it. And like you said, sometimes it would make someone see, all right, I actually don't have as good of a case as I thought, and theirs actually is pretty good, or vice versa. Now they've realized how good my case is, and they are going to pay me. So it was a way to really fast track these cases and clear the court's dockets. Generally, we would get to an arbitration within maybe 9 months, whereas if that arbitration award was going to be appealed and we were going to go to trial, you're talking an additional 9 months to a year. So it would cut the time in half. It still does cut the time in half. And it's a lot quicker of a process in general when you're talking about the actual process. An arbitration typically takes a half hour. Maybe I've had them last an hour, whereas a trial can easily be 2 to 3 days, believe it or not, even for a lemon law case. Pennsylvania's are still in person. It's an in-person proceeding where the plaintiff does have to show up. So I would show up on our client's behalf along with our client. Defense counsel would be there as well, and sometimes they'd even be bringing a representative from the manufacturer or their own expert. New Jersey, since COVID, has actually been remote, which has been great. The process itself is typically the same. We're still going to talk, we're still going to say the same things, but rather than having to travel to the courthouse in person, we're able to just do it via Zoom or Microsoft Teams or some other telephonic conference. And it's actually been really nice. It's a lot nicer for our clients. Rather than it taking a half day of their time, it takes a quick half hour. Some arbitrators, like the one that I had yesterday morning, actually just want to conduct the arbitration via phone and didn't even want any testimony. Honestly, those aren't my favorite. I do generally like to have our clients testify and provide their testimony. I think it is a lot more persuasive. I think it's really important. So I always try to push for that when I can. And I generally feel like Zoom or video conference is a bit more persuasive as well, rather than phone. But for the most part, you know, New Jersey's new standard of having these arbitrations conducted remotely has been great. It's quick, it's efficient, it's easy, and it still generally resolves these cases just as it does in Pennsylvania.
Yeah, I agree. So I've also handled some, arbitrations both pre and post COVID in New Jersey. And I do think that having them be remote, especially the arbitrations that are over the phone, are really difficult. It's like there's something lost, right? There's a disconnect. The arbitrator's not sitting there looking our client in the face, listening to their testimony. For example, so I had a case against Jaguar, right, in New Jersey. And it was a phone conference, and they did allow my client to testify. But the main issue, and we run into this a lot, is that it was an intermittent problem. Dealership didn't really duplicate it very often, but we had videos of it. And so we're showing the video, and the arbitrator said, and it was a pretty severe defect. It was a stalling issue that they were having that couldn't be replicated. And the arbitrator was like, well, you don't sound that scared or nervous or stressed in this video that you're taking. So, I don't know how much I agree that you think this is a safety problem. And I remember my brain just sort of exploded, like, because they're taking a video, they're knowing that they're doing it for us, right? We had told them to take the video. Do you want them in like a full-blown panic and screaming, or what were you expecting? So, and who knows, that could have happened in an in-person arbitration too. But I just remember that really stuck with me because I was just blown away by that being kind of the threshold and the standard. But that's, I guess, what you always run into with litigation, right? You never know the person who's listening to it, what kind of day they had, what opinion they're going to have on the issues. We like to think it's this perfect balance the scales system where everything's even and they just look at the issues, but they're people and they're human. And so sometimes they are able to sort of take that lens off and just look at the facts. And then other times they pull in these reasonings that we don't understand or that I guess what we just don't agree with. Like yesterday, Courtney, your arbitration, the arbitrator, we had videos of the same issue happening, right? I'll let you talk about it, but they discredited the videos too for, again, reasons that I'll let you explain that.
Yeah, like you said, Emma, these people are human, and sometimes we have great arbitrators and sometimes we have terrible arbitrators. And I have won cases I should have lost, and I've lost cases I should have won. And some of these cases, it really comes down to who your arbitrator is. And this is one where it was conducted over the phone. The arbitrator did not want any testimony, and it was an intermittent issue where the gas pedal would become stuck in the depressed position. And she would have to pull over to the side of the road, put the vehicle in park so that it was no longer moving, but it would still be revving. And she would have to physically reach down and pull up the accelerator pedal. Unfortunately, the dealership was never able to verify the issue because it was an intermittent issue. It would only happen every once in a while. She ended up totaling the vehicle in an accident that was completely unrelated to this issue. So our expert was not able to go out and inspect the vehicle and verify the issue. So the only evidence we were left with was her testimony and a few videos that she had taken. Unfortunately, the arbitrator would not allow testimony. She just had me talk about what the issue was. And as persuasive as I think I can sometimes be, it is not the same as someone testifying in person that her vehicle would not stop accelerating. She had small children in her back seat. She was in tears. She was terrified. It is not nearly as persuasive for me to sit there and tell that story in the third person as it would have been for our client to be able to tell that story in the first person. And so that's when sometimes I really prefer the in-person arbitrations where our client can sit there, you can look at them face to face, and you can hear their story and feel the terror that they may have felt. But so going back to the videos, we had a few videos that showed the issue, but all that it really showed and you could hear was that the vehicle was in park on the side of the road and it was still revving. And our client aimed the camera down so that you could see that her foot was not on the pedal was not being depressed, but you could hear the vehicle revving. And I thought that that was pretty darn good proof that the accelerator pedal was stuck, because the only way to make a vehicle rev is to depress the pedal unless it's stuck. That pedal has to be pushed down to make the vehicle rev. Well, the arbitrator said that no, it doesn't show that the pedal was stuck. Although we hear it revving and don't see anyone pushing the pedal, we don't know what could be causing that revving. Maybe something was stuck somewhere else or something was happening causing that noise. And it didn't matter how much I said to discredit that point, that no, the pedal does in fact have to be pushed in order to make that noise. She just didn't want to hear it. She said maybe it would have been better if we could see on the video that your client had reached down and was pulling up the accelerator pedal. Though I have a feeling that even if we were showing that, she would have said, well, we don't know how hard she was pulling. Maybe it just looks like she was pulling. Some people you just can't please, and it's going to depend who you get on that arbitration panel on that given day. I've had other times where I had an arbitrator reading the paper while I was talking. Another time where I had an arbitrator fall asleep while I was talking. And I understand that these are not always incredibly riveting cases, but you would think that they could at least stay conscious.
Yeah, I mean, when you told me that, because I watched those videos. I've seen them. Because I remember you and I were talking about this case in terms of, do we take it to litigation? What do we do with it? Do we think it's strong enough? And in my mind, okay, whether she had to pull up the pedal or not, the vehicle shouldn't be revving on its own when it's in park. So to me, yeah, sometimes they just focus on this entirely different issue that you're like, A, I didn't even think of that. And B, how does that matter? Right? Whether it was depressed or not, the vehicle's in park and it's revving. It shouldn't be. It should not be doing that, regardless of what we think is the ultimate issue. But yeah, but then also, I guess the flip side to that is I've had arbitrators, especially in Pennsylvania, who've helped me. So in the sense that, you do everything you can, right? But there's so many different ways to look at a case and so many different questions that you can ask, that while even doing the best you can, I've had it before where an arbitrator, because in PA, so PA is a little different than Jersey. Jersey is one attorney who is versed in lemon law, listening to both sides. In PA, you have a panel of 3 attorneys, and it's a little more formal than it is in New Jersey. It's more akin to, like you said, a little trial. You have your openings, you have your testimony, you have your experts. Everybody's there, basically. And I've had it before where the arbitrator started asking questions of the defendant's expert, and those questions were beneficial to me. And I was like, you keep going. You just keep asking those questions, oh, that was a good one. just a different perspective of looking at the case. It made it clear, at least, and we were happy when we left, there's no guarantees of what the outcome's going to be but when they start asking questions like that, where they're saying, well, what about this? Well, what about this? Or isn't it true that if you do X, Y, and Z, this shouldn't be happening? And they've actually helped us and be successful on the case. And we'll move on. But the last story I want to tell is this arbitrator that I had in Lancaster County. I'll always remember her. She was my advocate. So some of these arbitrations, as you know, can get pretty heated. Like us and the defense counsel, you do your best to keep your decorum and to keep your cool. But sometimes you can't help it. It is an emotional thing and you get very involved in it. And when they're saying something that isn't right, or they're bending the truth in a way that is manipulative, you just can't help but get upset. And in this specific case, so I'm not going to say who the manufacturer is, but so in this case, the client actually traded the vehicle in. And those are always really hard. When you don't have and the same thing with the vehicle that was totaled, when they don't have the vehicle anymore and the problem is essentially gone, it's really hard to get the arbitrator to have that sympathy or to have that understanding that they need to award in your favor, especially if you've gotten fair market value for it on trade-in. They're kind of like, no harm, no foul, you're fine now. So they had traded in the vehicle, and the defense counsel was trying to say that we shouldn't even be able to move forward with this arbitration because we had a spoliation of evidence. We got rid of the vehicle. We did not notify them. We didn't let them know so that they can inspect it if they wanted to. And so our case should basically be thrown out because we took the item or the evidence that we are arguing over and we trashed it. Like, we got rid of it. And so thinking about it from that perspective, it makes sense. But our argument to that is always, well, it's been to your tech centers. It's been to your dealerships so many times. Like, just bring in a technician, bring in the service manager. But in this particular case, I did notify them. I did let them know, but the person that I let know was subsequently let go from that firm. So while he knew, he didn't pass it along or didn't put it in the file. So it became a he said, she said thing. And at one point, he basically said that I was lying, even though I had like the notations that you take in terms of like emails. And we had spoken over the phone when I told him about the possible trade-in. And then I followed it up with an email, but the email was more like in reference to what we discussed. So it wasn't clear cut. And the arbitrator straight up said to him, are you saying that your fellow attorney, your sister-in-law, she called me, is lying? And he said yes. And you could tell that she was not pleased with that, not having it. And we were able to be successful on it. I like I said, emotions come into this. And I was just appreciative that, the panel stuck up for me. And we're like, okay, you're getting aggressive here. And you're basically calling her a liar when she does have evidence here that she told you. So long story short is that not all of them are bad, I guess is what I'm getting at. I know we tell a lot of stories about arbitrators looking at, these cases from a perspective we disagree with, but just wanted to throw in some stories too of when the panel actually helps us and when the panel actually can be really good and very involved. And I've definitely had, arbitrators reading the paper, but usually the other two are engaged, asking questions, and really listening. And these arbitrations can be really beneficial and can go really well, especially in Pennsylvania and New Jersey. But when it comes to picking what road to take and where to go with the case, I think it really depends, like we kind of said before, in terms of, okay, so now we know that we have all these options, right? We've got BBB, we have NCDS, we have the Attorney General's office, we have civil court. Which one do I go through? How do I pick the right one? That's where I think you really need an attorney. You need an attorney to help guide you because of all the collective experience, especially, just between Courtney and I in each one of these avenues, we can help you avoid any pitfalls or any errors that you might make. Like, for example, putting a case in front of the BBB when you don't even have a lemon law claim. Like, some people aren't really aware. So, for example, Courtney, New Jersey's lemon law is 2 years, 24,000 miles. And some clients are like, well, I had more than 24,000 miles, but it was less than 2 years old. So don't I still have a claim? and then they'll submit it through the BBB and they'll just get all out rejected because they don't qualify under lemon law, but they didn't realize it. Now, the upside is that these awards through at least the BBB and NCDS they're not binding on the consumer. They're only binding on the manufacturer. So you still have other avenues that you can go to in the event that you're not successful. But in some states like New York and Georgia, once you go through the Attorney General's office, if you fail there, you're done. That's it. You can't go to civil court. You can't do anything else. So that's why I think it's really important to be able to have counsel to advise you as to what's the best next step for your case based on your chances of recovery.
Yeah, absolutely. Like you said, Emma, there's a lot of fine print in the law that not everyone understands. I actually just had a client a couple of days ago who said, well, the lemon law says it's this amount of time or this amount of miles, and I am under this amount of time. And I pointed out that, well, it says whichever comes first. And she had just completely missed that. And like you said, in some states, if you miss that and you go in front of that alternative dispute resolution and you lose, then you're done. And there's nothing else that we're going to be able to do to help you. So it is always really important just to get that expertise. And we'll decide what the right avenue is. And even in a case like Pennsylvania or New Jersey, where it's not necessarily a one-shot deal, and if you're not successful at the BBB, yeah, we can always file a lawsuit. But why waste that time? Why waste those several months? You know, it's several months longer that you're going to have to hold onto the vehicle and work through all of this, and it's aggravating. So yeah, we would look at each case on a case-by-case basis and what state you're in, and we would let you know what the best way to proceed is.
Yeah, I mean, as recently as I think it was last week, I had a client that we signed up had contacted us because he had put his claim through NCDS, and his hearing is in 2 days from today. And we had just talked last week, and I went over his case, and I was like, you have a good lemon law case. You've got a decent shot. So, in worst case scenario, if NCDS decides against you, then we'll just, you basically just send a piece of paper back saying that you reject their decision, and that's all you have to do, and it's not binding on you. And so I basically told him, listen, you have the hearing coming up in a week. And I was like, this is what you want to say. Here's all the information that you want to include to be able to push this forward. Because if you can get a buyback in the next 2 weeks versus us, because we had just signed him, versus us taking it and it being a couple months till we get a response or an answer, I think you might be better off just taking your chances through NCDS. Let me know how it goes, and then we'll take things from there. But again, he had a very clean cut. I mean, the vehicle was still at the dealer and had been for over 6 months at this point. So to me, he had a very clean cut lemon law claim that I felt, yeah, if you don't need us, that's all the better. We're not here to put a monkey wrench into things. We're not here to complicate things. We're here to just get you to the end that you need to be in as best that we can. So I told him to go forward with it and let me know how it goes. And if he's successful, we'll just close it out and, be on our way. So it's definitely important to kind of know when to keep going with those claims, where to go through, and when to submit those applications, because other times, especially another case where a client just submitted to the BBB within days of us signing, we asked to withdraw it because at that point, it doesn't make sense to have both of them going, since we know the manufacturer, we know how quickly we're going to get an answer from them, and that the BBB is just going to stall the process.
Yeah, absolutely. And we certainly don't want to hold up a process. A lot of times we have clients who are in a defective vehicle. Well, all the time we have clients who are in a defective vehicle, but sometimes it's someone who doesn't want to hold on to that vehicle anymore. They're anxious to trade it in, and we certainly don't want to stall the process. So if you call us and, Emma, in the situation like you were talking about, you're already in the middle of it, and we think it would be beneficial for you to continue on, we'll certainly let you know that. We never want to, using your term, throw a monkey wrench in things. We'd rather you continue on, and if you don't end up needing us, that's no problem. We're still happy to give you some advice.
Absolutely. And there's always, as we say in every podcast, you always have our website too to go on for more information pursuant to your state's lemon law, so you can look specifically and see what does your state say. It's www.lemonlawcar.com. You also have your state's attorney general's office and the BBB website. The BBB website actually has a very comprehensive summary of every state and every state's lemon law. But your state's attorney general's office always has a webpage too that's dedicated to lemon law in your state that can be really comprehensive and really helpful in determining, do you have a valid lemon law claim? How do you go about pushing your case forward? And what sort of resources do you need or have in order to be able to do so? And as always, you can always call our intake line for a free consultation. It's 833-4CAR-LAW. And with that, we thank you for listening today and hope to see you again next time.
Thanks so much, everyone. See you next time.
Lemon Law Unpeeled is for informative purposes only. It is not to take the place of legal advice and does not create an attorney-client relationship between the viewers and Robison Lemon Law Group. Individual results also may vary as outcomes are determined on a case-by-case basis.